Hi, this is Jessica Sherk, and this is my final presentation for Business 343. I chose case 6, the work requirements for holiday pay case. The facts of the case are provided in John Budd's Labor Relations Striking a Balance, and they're fairly straightforward. Mr. Arnett was a truck driver and was entitled to receive holiday pay in observance of the Memorial Day holiday on his regularly scheduled shift, which happened to be the Tuesday after Memorial Day because he didn't normally work Mondays. While there's not a federal law requiring paid holiday benefits according to the Department of Labor and the Fair Labor Standards Act, it is part of the collective bargaining agreement in this case. And therefore, there is a legal requirement to provide the holiday pay benefit. However, the policy of the company, as well as the provisions in that collective bargaining agreement, states that employees must work the day prior to the holiday and the day after in order to receive that pay benefit. This is a common provision in company policies, contracts, and as well as collective bargaining agreements, according to Mel Muscovitz, who is an industry expert. Now, there is a provision in the collective bargaining agreement that would have allowed for the approval of a personal day off after the holiday and still receive that holiday pay if Mr. Arnett had requested his personal leave time in advance of the holiday, but he did not do that. Now, the union went ahead and filed a grievance requesting Arnett to be paid, stating that he did fulfill the requirements of the holiday pay, but he actually didn't fulfill those agreements that were set forth in the collective bargaining agreement. So that is what I'm contesting as the HR manager. So as the HR manager, I feel the employer's position is accurate based on the facts of the case. Mr. Arnett did not fulfill the collective bargaining agreement by choosing not to work the day after the holiday. Therefore, Arnett chose to forego his paid holiday benefit. Furthermore, Arnett did not receive advance permission to take the day after the holiday, that Wednesday, off, which is the company policy and part of the collective bargaining agreement. Now, again, this rule may have been waived in advance of the holiday, and the employee could have requested consideration, but he did not do that. So the union's position representing Mr. Arnett here is that he had personal leave time available and chose to use it the day after the paid holiday, which I don't contest. And as well, past practice allowed for people to be paid for personal leave days, even if not requested in advance. And that's true. That is something that had been set forward. Okay, so the presentation of the HR case. According to Chris Hopping, in each grievance, it's important to keep in mind that all employees have the right to take their grievances to arbitration unless the employer proves that the grievance is invalid. Therefore, it's important for the HR manager to present a thorough and effective case. While I certainly empathize with Mr. Arnett's position and his disappointment in not receiving his holiday pay benefit, Mr. Arnett should have been aware of the collective bargaining agreement and his contract provisions regarding holiday pay. In fact, he signed his contract affirming that he knew the provisions contained therein. While there has been an established practice of shift managers allowing paid personal time off, even when a policy of advance notice is not observed, this is not the issue in this case. Mr. Arnett did receive his personal paid day off, even though he didn't ask for an advance, but he did not receive the holiday pay prior to that day. That he should have requested advance permission for. So there is a trigger in place to receive holiday pay in their collective bargaining agreement. And that is that the employee must work their regularly scheduled shift to the day prior the holiday and the day after the holiday. Or alternately, Mr. Arnett if he had honored his contract by requesting the time off in advance, his request may have been approved and his holiday pay benefit could have been triggered. He did not do that. Okay. So a couple more items just as additional evidence for the HR argument here. This is a quote from professors Roger Abrams and Dennis Nolan, and they're writing for the Case Western Reserve University Law Review, where they said, entitlement to holiday pay depends upon the terms of the collective bargaining agreement. The deal struck by the parties at the negotiation table must control. And so clearly we can see that that he did not follow that deal. Furthermore, a collective bargaining agreement is the agreement reached at the conclusion of the negotiations. It is considered to be legally binding for both parties. So if it has to be legally binding for both parties, certainly Mr. Arnett has to uphold his end of that bargaining agreement as well as the employer. So some next steps for the HR manager, myself in this case, to keep in mind. According to the Society of Human Resource Management, the grievance procedure will have one of three possible outcomes. The supervisor and the union representative may determine that no grievance exists. The grievance may be resolved, and the grievance may not be resolved to the employee's satisfaction, and it will move forward to the next step in the process, which could have been arbitration or something else that is not the case here. If I successfully argue my case, the union rep will agree that there is no grievance, and Mr. Arnett will concede that he did not follow the proper procedure to ensure he would receive the holiday pay benefit. My next steps then would be to clearly outline how this problem can be avoided in the future by reviewing the holiday pay benefits with Mr. Arnett. I would also want to make a point to seek out Mr. Arnett in the days and weeks following this disagreement, just to really smooth things over, to really let him know that the company appreciates his work, and to try to make sure that there isn't any underlying hostility. Finally, I would immediately want to determine if a company or a stronger company-wide communication needs to be implemented regarding employee benefits and policies. Perhaps a training is needed to help make sure that the employees do understand all of their holiday pay benefits available to them. So in conclusion, as an HR manager and a Christian, it's important to always strike a balance between serving our employer's best interests and being a peacemaker with employees. Jesus affirms that peacemakers will be blessed on the Sermon on the Mount. And also Paul reminds us that we are called to live at peace with all people as much as we possibly can. And I think as managers in this situation, that is really on our responsibility. And here are my references, which are cited in the notes section of my PowerPoint presentation. Thanks very much.